Yes, please. Yes, please.
This is the PIL regarding the school structure, my lord. On the last occasion, my lord, on 9th of December, your lordship had passed certain directions. Form a committee. Last page of the order, my lords. Last paragraph.
Mr. Khan, you have submitted a
You
report?
submitted the report. And Your Lordship, the recommendation of the committee is at page 2, Your Lordship, the recommendation. The relevant part. You got it? Yes.
Who's representing the school?
I'm representing Your Lordship for respondent 4 and 5 for the school.
What are you proposing to do?
Your Lordship, actually,
Demolish the building whole hog?
it's already demolished the building, Your Lordship. The entire building was demolished and then construction was started. The permission got actually right from the 2 stages, right from the month of October last year. And Your Lordship, I have very important points to bring to the attention of Your Lordship.
No, when was the demolition done?
The start of demolition was right from October onwards.
When was our order passed?
Your
9th of December, my lord.
9th of December.
So when this was moved, the demolition was over?
No.
No, my lord.
Major foundation, all the major foundation was already demolishing. Only except some part of the classroom and structure was there because waiting for the end of the year. This building is housing for 650 students, young students, Your Lordship, right from the age of 4 onwards. It was in a very bad condition. After done all the tests, approached the government for proper permission with all the plans, then the government also approved. Then we move ahead for the new construction. Perhaps besides that, Your Lordship, this PIL actually, it was filed for personal gain and interest because this group named as Intact had approached us several times before to hand over them to do the planning and the construction. So therefore we refused and then they have come up with this one. And I have on record, Your Lordship, to bring for that.
But as per the report,
Demolish it after the order.
after the order, my lord. As per the report, my lord, 16th of December, the committee had inspected the building. The building was still intact. 16th December, my lord, inspection was carried out by the committee as per the report also.
Lordship, the main facade part of the that was still intact.
Your Lordship, actually all the foundation was demolished, so therefore even the main facade cannot support anymore at that time. We have all, Your Lordship, on records. Your Lordship can allow us, we can file the affidavit on this matter. And Your Lordship, this building was never a colonial building, Your Lordship. It was all only built up between 1949 to 1952. All the facts were misrepresented before Your Lordship.
When was the inspection carried out, Mr. Khan?
16 December.
Where do I get it?
Page 1 of the report, note, first paragraph.
Especially para 2, Your Lordship, page 16, page 1, sorry. Reports para 2 is very important. Para 2 of 16 December 2024. So as on 16 December 2024, the structure was in existence and there was an inspection on. The other relevant para is para 6 and 7, same page, para 6 and 7.
Only the roof.
And very, very important, crucial point is at para 8. At the time of inspection, initiation of dismantling of the roof of the building. Para 8. When is the High Court close? 18. 17. 17.
The statue of Don Bosco is there, or that is also gone.
No, that
No,
is
Your Lordship is there. It's only the building.
only the building.
By the time this PIL was filed, Your Lordship, and the authorities came for inspection, all the major foundation was already demolished. Because we received the last permission was on 3rd October 2024. The first stage itself, we start from July. And Your Lordship, as per the Ancient Monuments and Archaeological Sites and Remains Act 1958, building of such structure to be considered must be at least not less than 100 years. And this building has not met that 100 years, even as per that act. And the construction of the new building comes only because at the risk of the children who are there. And in the report itself, Your Lordship, you can see there in the report itself that we have attached also. In the report of the government report, that page 10, that we have done all that non-destructive tests, and it comes up very poor. Page 10, and the result Your Lordship, is at page 13. Of the test. The result is at page 13.
Do you have a determination? Which judge takes which subject matter? Or does anything for overreaching the court of criminal contempt rules we should? They have no business proceed with the after the inspection. It's a very daring act they have done. And we have the determination period. Yes. This page 189. Any other submission to be made?
Lordship, under the Act, the Heritage Act, page 30, clause 6. Right now, what has happened, Lordship, as per the direction of this court, the committee has conducted inspection with all the stakeholders and then submitted a report. So once the report is submitted, Your Lordship, the government has to act as per section 6. Lordship will kindly have it at page 30. So this is an authority, Your Lordship, that will sit over the recommendation by the committee and then decide. And Your Lordship, 7, page 31, 7, subclause 1.
Of the report.
Not report, Your Lordship, I'm relying on the PIL petition one. I'm just reading the relevant part of the Act, Ajay. First would be, Your Lordship, page 30, the clause 6, it's an authority.
Hmm.
30. This will consider first, the entire details has been let out, Your Lordship, in the Act. And once that is done, Your Lordship, then under 7.2, then the power lies with the government to grant permission or reject.
Yes, please take down.
And Your Lordship, last submission, Your Lordship, as per section 12, even, government has to create a heritage fund. Now that fund will be additional fund to
We
preserve
will
the.
go into that later. We have to deal with this first.
Lordship. No, I'm just saying, Lordship, all this process cannot be set into motion by popular making submission, Lordship, because the report has been given that it has to be declared. Now, when the main building has been demolished, as per the submission of my friend, so the entire setting into motion, section 6, 7, and 12 would be frustrated. Oblige.
We are most perplexed and shocked at the most daring act committed by the management of the school. Management of St. Anthony's Lower Primary School. Please read out.
We are more shocked and more daring and committed by the management of St. Anthony's Lower Primary School.
After our order dated 9th December 2024. Paragraph. This public interest litigation was initiated on the allegation that the school was run in an Assam-type colonial structure of significant architectural and historical value. It was fit to be declared as a heritage building, full stop. However, the management of the school was proceeding to demolish it. Paragraph. To rule out any vested interest involved in this litigation, we directed notice to the school authority. Full stop. Comma. So as to hear them and satisfy ourselves now to hear them along with the petitioner and the respondent state as to whether at all the building was heritage and worthy of being preserved, comma, by stalling its demolition and restructuring, full stop. By our order dated 9th December 2024, we directed the state to make an inspection and conduct an inquiry under the Meghalaya Heritage Act 2012 and to report to this court regarding the heritage value of this building. Paragraph. As the school was not represented, we thought it fit not to pass any order affecting it in their absence, full stop. Hence, we did not make a formal order restraining further demolition activity, full stop. It was expected from the school that when they were noticed and required to appear in court and the state directed to make an inquiry into the status of the building, they would not make the exercise infructuous by proceeding with the demolition work. Learned Additional Advocate General Mr. Khan has duly submitted a report before this court. Full stop. We find from it that on 16 December 2024, an inspection and inquiry was duly made under the aforesaid Act. Full stop. The most important part of the report is that this school overlooks Don Bosco Square, where the statue of Don Bosco stands installed. It overlooks the facade of the school. Full stop. Don Bosco Square is a very important and popular feature of Shillong. Full stop. Although the building as such does not classify to be declared as heritage, comma, on a combined view of the square, the statue thereupon, and the facade of the school facing it, the recommendation of the committee making the recommendation of the joint director and member of the Meghalaya Heritage Subcommittee, Urban Affairs, Meghalaya, was that the building should be listed as a heritage building under the said Act. Full stop. He recommended that the state should issue necessary directions he recommended that considering his view, the state should make the necessary, should issue necessary directions with regard to construction or alteration. The construction in construction concerning or construction or alteration within, you put that within quotation, construction quotation, alteration quotation, concerning the building. Therefore, it is clear as daylight that on 16 December 2024, the building was existing. Paragraph. Today it is submitted by learned counsel for the school that the building has been entirely demolished. Paragraph. Therefore, nothing remains of this public interest litigation, and it has been effectively destroyed even before consideration by the school authority. Paragraph. We take a very serious view of this matter although there was no formal order restraining demolition of the building, but this act prima facie constitutes criminal contempt and a most daring challenge thrown to the authority of the court. Accordingly, before considering any other issue in this matter, we direct a notice under the Contempt of Courts, bracket, High Court of Meghalaya, bracket, rules 2013. Who's the head of the school?
It's the principal.
Hmm?
It's the principal.
What is his name?
His name is Rafael Tham.
Who else is in the management?
Management. Yeah.
Please give all the names. Who are responsible for taking decision, not people who are subordinates.
This is the principal.
Only he takes the decision.
He takes a decision.
Managing committee.
Managing committee.
Managing
He-
committee, my lord. Managing committee of the school.
Give their names. Of all the members of the managing committee of the school, namely, I, with their address. Returnable on 24th February 2025, when they should be present in court at its first sitting. Paragraph to prevent any further contemptuous act, and as an interim order, we direct that no further activity with regard to demolition, construction, or alteration of the existing building shall be carried out until further orders of this court. The local police authority is to ensure strict compliance with this order. A copy of this order may be sent by the learned Registrar General of this court to the local police authorities. List this application once again on 24th February. What is all this? Right. It was complied with?
My lord, it has been complied, my lord. And, my lord, the fresh affidavit has been filed We have received a copy of, my lord.
Yesterday, Your Lord.
And all the issues, my lord, which has been raised in this instant case, my lord, has more or less has been complied, my lord.
Been addressed and complied.
Yes, my lord. Only one point, my lord.
You found that they have taken some steps.
Only one issue, my lord, which I would like to mention it before this court. There are speed breakers in the roads, my lord. These has to be painted so that it is visible, my lord. Otherwise, sometimes it's very difficult.
What is the subject matter of the PIL?
My lord, this is pertaining to these the two-wheelers, my lord, rash and negligent driving and
Only
road
that?
safety. Road safety, yes, my lord.
Only.
Only, my lord, yes. Road safety, my lord, that was the subject matter.
Then it can be disposed of.
My lord.
Lordship, yes.
Only if some direction can be given as regard to the speed breakers for painting it, my lord. Otherwise, it is not visible, my lord. Sometime.
Painting and some signage that
Yes,
speed breaker ahead.
right, right. my lord.
Lordship,
Yes.
that will do, Your Lordship. That will do, Your Lordship. Don't jacaba for speed breaker.
If there is non-compliance, there will be no contempt application. We can dispose of it. That you, only thing that remains is complaint with regard to speed breaker and signage, you do it and we dispose of it.
My lord, the state has installed cameras, and whether those cameras are functional or not, my lord, it is not mentioned in the affidavit, my lord. They were supposed to be functional by December.
Lordship is functional now. It's functional, Your Lord.
They are called speed guns or what are they called?
My lord, speed detection devices also.
This is for detection of speed or, and other activities, Your Lordship.
All right. After hearing learned counsel for the parties,
Especially criminal activities, Your
we
Lordship.
are satisfied that our order dated 16 December 2024 has been complied with to the satisfaction of all stakeholders. We dispose of this public interest litigation with the following directions: I, the government will suitably mark the speed breakers so that they are discernible from a reasonable distance. It would be desirable if the speed breakers are preceded by a signage.
Lordship, wherever possible, Your Lordship, because they are
Wherever
Your
possible,
Lordship.
yes.
Lordship.
Wherever possible,
Lordship, I'm
so that the
complying,
motorist can be made aware of the need to reduce speed. III, the state is to ensure that speed detection devices wherever they are required
Lordship.
are suitably installed and maintained.
Lordship.
That's all.
Highly obliged.
Obliged.
Yes, please.
Lordship, the paper books have been circulated, Lordship.
Yes.
The paper book has been circulated, Lordship. We have served the paper. Lordship, we are aggrieved by the.
You are ready, both of you?
I'm ready, Lordship.
Proceed.
Lordship, we are aggrieved by the order dated 16/7/2024, passed by the learned single judge in WPC 129 of 2024. Lordship, Lordship, before coming to the impugn order, Lordship, I would just like to state the brief fact of the case, Lordship. Lordship, the appellant herein is working as an assistant director in the physical education department under Northeastern Hill University. Lordship, what has happened in the year 2023? In the year 2023, there was a complaint against him. And because of that complaint, Lordship, he's placed under suspension. That suspension order is at page 19 of the paper book, Lordship. Now, the suspension order is the respondent's authorities has invoked the Rule 10(2) of CCS rules and placed him under suspension. Now, Lordship, the Rule 10(2) of CCS rules prescribes that the suspension order has to be reviewed within the period of 90 days. Before the expiry of 90 days, the suspension order has to be reviewed by the competent authorities. Now, in this case, Your Lordship, the suspension order, though it has lapsed for more than 90 days, now the respondent authorities has not taken any steps to review the suspension order. So, by virtue of Rule 10(2), Lordship, the suspension order has become redundant and it has become inoperative and it has ceased to operate. Now, Lordship, since the respondent authorities have not taken steps to revoke the suspension order, we had approached
Yes.
the single bench, the learned single judge, Lordship, by way of this writ petition. Our primary ground is that, Lordship, since the suspension order has not been modified or revoked under Rule 10(2), that suspension order itself has become inoperative, and as such,
DP has been started.
Lordship,
DP has been started.
DP has not been started at that time, Lordship. It was only after we had filed a writ petition they took steps, Lordship. Now, Lordship, the single judge, the impugn judgment, Lordship, may kindly come to page 49, Lordship. Page 49 of the paper book is the impugn judgment. Now, the relevant paragraphs will be at para 7, Lordship, page 55. I may read, Lordship, para 7.
Primarily, Lordship, we are aggrieved by para 11 of the impugned judgment, Lordship.
You're for the university.
No, I'm for the appellant, Lordship.
How are you aggrieved? Suspension is revoked.
Lordship, para 10 says that the suspension has been revoked. Now, para 11, Lordship. Para 11 says, Lordship, the repetition is therefore allowed, but this order shall not be taken to preclude the respondents from taking such further action as necessary under the law or as provided under section 10(1) of the CCA Rules 1965. Lordship, our case is that once the suspension order was not been reviewed or revoked and as upheld by the learned single judge, Lordship. Lordship, now I'm being placed by para 11, Lordship. The liberty is being given to the respondent authorities to issue fresh suspension order, Lordship.
Suspension is subsistence allowance. Then if suspension continues, more subsistence allowance. Thereafter, revocation of subsistence so that you don't get money without working and you're put back into work. Unless your presence is detrimental to the workplace.
Lordship,
It has got nothing to do with further action.
Lordship, may kindly come again to page 19, Lordship. Page 19 is the first suspension order which have been suspended.
Maybe.
The Lordship, at that time when the complaint was there in existence, Lordship, the university has taken steps and invoked Rule 10(2) of the CCS rules and punished me, Your Lordship, and placed me under punishment, Lordship. Now, Your Lordship, the single judge goes on to say that, okay, the order which has been passed under 10(2) is no longer valid. Now the respondents can take steps under 10(1), Lordship. How
What
can
is
I be?
10(1)?
Lordship, 10(1) is punishment or suspension, Lordship. May kindly come to the rules, Lordship.
Show us the rules.
Part 4 of the CCA rules, Lordship, pertains to suspension. Rule 10 pertains to suspension, Lordship.
Look at 5B of the rules.
Lordship.
Small b. Please read
Lordship. 10(1)(b), Lordship.
5B. 10(1)(5)B. That is what his lordship meant.
Lordship, my case is that, Lordship, when the suspension order was,
For that particular act, suspension, revocation. Now you are back to work.
no, Your Lordship, I'm still under suspension.
No, very good. Suppose your suspension is revoked and you are back to work and you do something else. Does it mean that you can't be suspended again?
Lordship, I've been suspended. There's no fresh complaint or there's no
It's
fresh
all right.
misconduct against
So that is what his lordship has said. Try to understand.
Lordship, it's not the case of the respondent, Lordship, in my humble submission, that the earlier suspension order was revoked or recalled or withdrawn by them, Lordship, to warrant any, Lordship, and there's no power vested with the respondent, Lordship, to issue another fresh suspension order, Lordship, under 10(1), Lordship, because I've already been suspended under 10(2), Lordship.
In respect of that act, no more suspension, but if he does something else, he can be suspended. We'll clarify that on dispositive. We'll clarify that on dispositive.
If it is a continuation of the earlier process.
The judgment and order dated 16 July 2024, from a part of which the appellant has preferred this appeal, is substantially, if not wholly, in favor of the appellant. Paragraph. In reality, what the appellant wants in this appeal is a clarification of paragraph 11 of the judgment and order, by which the writ petition was allowed, but his lordship stated, underlined partner, page 57. Paragraph. Learned counsel for the appellant contends that after the suspension order is deemed to have been revoked, or set aside by the impugned judgment and order, there could not be any further suspension under section 10 within bracket 1 of the CCS bracket CCA bracket closed rules 1965. Rule 10 in Chapter 4 deals with suspension. Rule 10 in Part 4, Roman 4. Rule 5 stipulates that if during continuation of suspension another proceeding is started against the delinquent and he is placed under suspension, in spite of revocation of the sentence of the first suspension, his suspension would continue till revocation of all suspension orders. Or till the expiry of the suspension order, whichever is later. Paragraph, it follows from the rules that revocation or setting aside of a suspension order does not necessarily prevent the disciplinary authority from passing another suspension order in respect of any different or further act. In our view, this is the interpretation to be given to the impugned judgment and order. Another order of suspension on the self-same cause of action cannot be maintained, but the authority is free to exercise powers under Section 10 in case of any independent act of the appellant with which they may be aggrieved. Paragraph, with the above observation and clarification of the impugned judgment and order, this appeal is disposed of. Full stop. We have not interfered with the impugned judgment and order, but only interpreted and clarified the same. That's all.
Item number 4.
Yes, please.
May I please, Your Lordship?
Yes.
Your Lordship, in this matter, we're challenging the vires of the amended service rules, Your Lordship. Specifically, Rule 7, Your Lordship, where filling up vacancies by way of direct recruitment has been increased from 65% to 75%, whereas promotion opportunities has been reduced from 35% to 25%, Your Lordship. Your Lordship, I pray that this matter may kindly be, this matter may have, after 2 weeks, Your Lordship, for further preparation to this matter.
No objection.
By consent of learned counsel for the parties. This writ petition is adjourned to February 11th. All right?
Obliged, Your Lordship.